presented by GMG EnviroSafe. I'm Melissa Jolls with RDA Impact, and Brandon Thomas, Chief Operating Officer for GMG EnviroSafe, is your presenter for this webinar. The presentation will take approximately 45 minutes, and we are recording it, and we'll post it on our website under training videos as well as on our YouTube channel. If you have questions, you can type them in the chat box at the bottom right of your screen, and Brandon will answer those at the end of the presentation. Now I'll turn it over to Brandon.
Thanks, Melissa. Good afternoon, everyone. I appreciate you taking time out of your day to listen to me talk about OSHA and how it's impacting the collision repair industry. If you didn't participate in our first installment, we, fourth quarter of last year, talked from a high level on OSHA's National Emphasis Program in isocyanates and how that's changing the landscape for regulatory involvement in the body shop world. We weren't really able to do a lot of deep diving at that webinar. We talked from a 30,000-foot view, but what came out of that was a lot of good questions from some collision repair operators that we didn't have time for. So I'm excited to be back here today with you all to take an opportunity to take some of those questions that we got and really dive into the weeds a bit and explore that. I also have a case study. We have a customer that came to us in the last couple of weeks that just went through an OSHA inspection, and I've gotten their permission to share with you all the documentation and the paperwork that they received, obviously with their identifying features such as name and address blacked out. So we will dive right in without further ado. As Melissa said, my name is Brandon Thomas. I think it's important just to give you a little bit of background about me. I am not an industrial hygienist. I am not an OSHA inspector that went into the private sector. I started in this industry on the shop side of things. I worked for a company called Collision Revision. We had 30 shops in Chicago and did that for approximately five and a half years. So when I approach issues like OSHA, EPA, regulatory compliance, employee safety, that sort of thing, I'm always coming at it from the perspective of the shop side of things as opposed to the regulatory side of things. Currently work with GMG EnviroSafe. A very brief overview of what we do. We've been servicing the collision repair industry for over 25 years exclusively. We handle EPA, OSHA, DOT compliance, set up employee safety programs, and handle risk management strategies, and we cover the entire United States currently. At the end of this presentation, we'll spend a bit more time elaborating on what it is that we do for shops, so stick around for that. Where I'd like to begin is one of the questions that I often get from shops when I do presentations or if I'm at association meetings, and it's a bit asking me to be a fortune teller, so to speak. And that question is, what do you think my shop is doing right now that makes me not OSHA compliant? And that's a bit of a tough question to answer when there's 305 different OSHA standards that apply to the collision repair industry. There are plenty of ways to have issues or violations. But last year, we did over 7,000 audits of body shop customers across the country. And so what I did in preparation for this webinar is I went back and looked at the trends to see what the most common violations were across those 7,000 customers. And a clear pattern started to emerge that was tied to your paperwork. When it comes to OSHA, a lot of shop owners aren't intentionally trying to create an unsafe work environment. Most body shops that I deal with are very conscientious. They want to look after the health and safety of their employees. They want to do the right things. But on the paperwork side, this tends to be a bit of a blind spot, mostly because shop owners haven't been told the sheer amount and complexity of paperwork that affects their business. To illustrate this, I just wanted to put together a slide that just included the required paperwork from an OSHA standpoint. Now, this doesn't get into EPA. This doesn't get into fire department or municipal regulations. This is just paperwork that OSHA requires. We're going to spend some time going through this list. Now, there are some state-to-state variations, and I will point those out as we go through it. But for the most part, 80% of this list is a requirement for every body shop in the country. In the upper left-hand corner, you have hazard communication plan, respiratory protection plan, emergency response, injury and illness prevention, lockout, tagout, and forklift plan, those first 6. These are all written plans that a body shop must have in their day-to-day operations. Think of these like a business plan. So every shop must have some documentation in writing that talks about what the policies and procedures are as it relates to worker safety. What that means is a hazard assessment has been done, and you'll see that right underneath the forklift plan, where you have all the different repair procedures and operations that a person that might be a body tech or a painter or a detailer are going to do with their normal job responsibilities, and then how they can be hurt. So if I'm a body technician and I'm responsible for sanding, grinding, welding, working underneath a vehicle, the hazard assessment, which by extension becomes a part of the hazard communication plan, is essentially a listing of all of those tasks. What are the ways or the risks or the hazards that that person can be injured or become ill, and then what personal protective equipment or PPE does that person need to be wearing as a part of the policy of that particular shop. So working under a vehicle requires safety glasses. Handling chemicals requires hand protection, such as latex or nitrile gloves, that sort of thing. So if your business does not have this series of written plans that talks about the chemicals, what their health risks are, how they're going to be labeled, where to find safety data sheets, if you do not have something in writing that documents your respirator policies, such as the types of respirators that you're using, who is going to be wearing them, when they have to wear them, how often they have to change those pre-filters, what the log looks like when you do change them. If you don't have that as a business plan, then you do not have the required written plans from an OSHA standpoint. And those typically, when we start working with shops, are the big glaring misses, so to speak, in terms of where they need improvement. Moving a little bit further down, the OSHA 300 and 300A, there is some variability here. Typically, it's tied to the number of employees in the business. If you have 10 or more, this becomes a requirement. If you have less than 10, depending on what state you're in, you might not have this as a regular requirement. But an OSHA 300 is essentially a document, a report of all the different types of injuries and illnesses that have occurred in your business over the course of the last year. And then you have to keep those on file for a 5-year period. When you get into the reporting period, it's February 1st to April 30th. Those OSHA 300 logs have to be posted in a break room, and they have to be left up for that 60-day period. Most shops' labor and wage posters are okay. Typically what I see, and again, this is going to be minimum wage, overtime rules of your particular state, the healthcare laws of a particular state, child labor laws, that sort of thing. Usually a shop's going to have an all-in-one poster that might have 6 to 10 different areas of content. But what we see is that they are either outdated. Whenever there's a regulatory change, let's say minimum wage has increased, those posters have to be replaced. Or on the flip side of things, we also notice that shops tend to sign up for subscription services where a poster company will just send them a new poster every year. And that actually isn't a regulatory requirement. The poster companies may modify their design, they may modify some language that isn't relevant to the regulation and say, hey, Mr. Body Shop owner, we have a new poster. Do you want to purchase it for $100 or $150, whatever it may be? The reality is that you only need to update these posters when there's a regulatory change, something in the language of the regulation or the laws, such as, like I said, a minimum wage increase. And we have some states that haven't made any changes since as far back as 2009, 2010. So depending on how current your poster is, that could be a gap for your OSHA paperwork. Monthly safety meetings are relatively straightforward. This isn't really a complex thing. It's just an ongoing safety process with a sign-in sheet, some documentation of who was in the room when they conducted a safety meeting, what was discussed, and placed in a file. Normally a shop's going to keep these for a rolling 12 months. Jumping into the right column, hazardous chemical list and safety data sheets should be pretty straightforward. Everybody should be comfortable with the requirements as it relates to SDS. However, typically when we look at a shop, the gap is on the hazardous chemical list. What you're required to have here is, think of it like a table of contents. Let's say you're a shop and you have 300 chemicals in between the paint, body, and detail departments. You know, every individual pearl, toner, body filler, seam sealer, degreasers, that sort of thing. Even if you have all of the SDS, that's part of the equation, you also need to have a hazardous chemical list that lists every single chemical that's in the shop. Most people will throw this in the front of their binder and, again, treat it like a table of contents. Keep in mind, we've now entered in where we're 12 months away from the next major OSHA deadline as it relates to shops. So OSHA updated their hazard communication standard in 2012. There were changes to safety data sheets, new content. There was changes to labeling requirements, pictograms. If you sat in on this webinar at the end of last year, we went over that in detail. So the shops had a training requirement December 1st, 2013. Well, now it's gone away for a couple of years, and the work has been on the distribution and the chemical manufacturer side. However, there's another deadline coming June of next year where the shops will now have to convert their entire libraries over to SDS, as well as the training programs, written plans, posters, anything that references the old standard has to be replaced. So bear that in mind. We're now less than a year away from another deadline where the shops have to get involved and get engaged and change out their hazard chemicals and safety data sheets. Auto lift inspection, this applies to 2-post, 4-post, in-ground, your traditional above ground, anything that's going to lift a vehicle has to go through an annual OSHA inspection. This is going to be done by an ALI certified technician, someone that works for a lift company that does maintenance or installations. It's not just a maintenance check. They're going to spend anywhere from 2 to 3 hours on each individual lift. They're going to document all kinds of features with that lift to make sure that it can pass a safety inspection per the Automotive Lift Institute. And then you as the shop owner need to have that documentation essentially certifying each individual lift. That's very important. I talk to some shops where they'll have just one looked at and they think that that certification extends to the entire facility. And the reality is that every individual lift has to go through an automotive lift inspection, and they have to be done once a year. So you have to make sure you're staying current in that regard. Respirator, this is the one that most shops do very well with. This is something that has gotten through to the industry very well. Medical evaluation, medical screening. If one of your employees is going to be wearing a respirator, a tight-fitting respirator, that also includes dust masks, welding masks, that sort of thing. If they're wearing that type of a PPE, they have to go through some type of medical screening. It doesn't mean they have to be sent to a doctor for a physical. Doesn't mean they need to go through some extensive testing. Essentially, they need to fill out a health questionnaire, and a licensed healthcare practitioner has to look at that and then sign off that that person is okay to wear a respirator or a mask while they're working in your business. That is good for the duration of their employment. You don't have to do that on an annual or a semi-annual basis. As long as their health and the work environment doesn't change from year to year, then the medical evaluation will last. The fit test, where someone will put typically a hood or a bag over someone's head, have them wear a respirator, spray some solution into the hood and have them do breathing tests, that sort of thing. That fit test is an annual requirement. So sometimes shops will get that confused and they'll think the medical evaluation and the fit test is annual, and it's just annual for the fit test, not for the medical evaluation. Air monitoring results. If you're a shop owner and you're using respirators in the shop, at some point you have to have done some type of air monitoring in the paint department specifically to determine how frequently the respirator cartridges have to be changed. You can't just rely on, well, I think the respirator will last 3 weeks or 4 weeks, or the person that sold it to me told me that it would last 2 weeks. From an OSHA standpoint, that is not adequate. You have to have done some type of vapor air monitoring test to determine, based on your work environment, based on your ventilation, based on the chemicals that you're spraying, this is the type of change-out schedule that you can have for a respirator. And then the last section, now forklift, probably about 10-12% of our customers have forklifts. This isn't really a common issue in the body shop world, but if you do have a forklift of some kind, they need to have daily inspection records. You have to have licenses to drive them for anyone in the shop that drives that forklift. And then on the logs side, from an OSHA standpoint, there are certainly more logs that are required from an EPA, but just from an OSHA standpoint, you have a change-out schedule that needs to be documented whenever you change respirators for your technicians, as well as an eye wash station inspection. So if you have a plumbed eye wash or you have a cabinet style, typically those have to be inspected weekly for obstructions, for debris, for damage, that sort of thing. Make sure you have good water flow. and then you have to document that. So I hope you get the sense that the level of paperwork required from just an OSHA standpoint is significant. Most shops will have a smattering of this, where maybe they've done some medical evaluations. They probably have a binder full of SDS. They may have done some, they might have a labor and wage poster, they might have safety meetings. But this is typically our focus area when we start working with shops, because it's the biggest blind spot. So when I get asked the question, where are my disconnects, where are my violations from an OSHA standpoint, what am I doing right now that's not compliant? Typically, I'm going to go right to the paperwork, because there's just so much of it that you have to keep track of that there's going to typically be gaps. Moving on. The second question I got is, if I go through an OSHA inspection, they come out to my facility, what happens after that? And true to form, with OSHA having such a focus on paperwork in the business, you can expect to have to deal with more paperwork. With an OSHA inspection, they could be out there for a few days, they could be out there over the course of a few weeks. Then they're going to take some time to put together the packet that they're going to send your business that details the violations that they saw, what kind of penalties they're going to assign, and then what your rights and responsibilities are. So it's essentially more paperwork. As I said at the beginning of this session, I was able to get my hands on a shop that came to me after they received an OSHA inspection. They just got their paperwork a few weeks ago, and I thought it was great to be able to share some of their experiences with the audience, and I got their permission. So bear with me as I bring up some of these documents here. You're going to see some pop-ups on my screen. I apologize for that. So the thing I want to point out is you're going to get a package after an OSHA inspection that could be 20-plus pages in length. It can be pretty intimidating when you go right to the back of the page and you see what the invoice looks like. And that's why I wanted to include this first. Typically, whenever we're dealing with OSHA inspectors or shops, everyone kind of flips through all the legal mumbo jumbo and just goes right to, what does this mean for my business? And they've got the total proposed penalties right there. Now, I've broken out all the different citations, and we're going to get the opportunity to dive pretty deeply into each of those, and you guys are going to be able to see that firsthand. The one thing that I did do is you're going to notice that I blacked out the company name, address, date, inspection number, so there's no way that we can have this tie back to the business, and we can kind of talk through this at more length. So where they started is they were levied $9,400 in penalties, and they broke them into two classifications of citations, one being serious, the other being other than serious, which is a lesser classification, so to speak. And they've got 11 pages of citations, and I'm going to show you those right now. Scroll all the way up to the top. Okay, your screen should have refreshed. So you'll notice that the date at the very top is important. Inspection date, April 14th, 2015. Issuance date, June 2nd, 2015. That's important. When OSHA comes to a shop, typically it can be a bit traumatic, not necessarily because the shop is doing anything wrong, just because it can be an unsettling experience. I'm not really sure what's going to happen, knowing that it could cost you money, knowing that you're not perfect, that you're not compliant 100% of the time. Maybe you know you've got some paperwork issues, or maybe you've been meaning to fix something, that sort of thing. They're there for a day, maybe a few days. Then they go away for a few months and you don't hear anything, and you kind of forget what the experience was like until this shows up. The important thing is, as soon as you get this documentation, the clock is already running. So it's very important that if you do go through an OSHA inspection and you get this citation and notification of penalty, that you process the information, you read through this all very, very quickly. You do not want to sit on this for a few weeks, because then your rights and responsibilities have completely changed because you didn't respond in a timely fashion. We'll be able to spend some time talking about that. So citation 1, these are all the serious citations. They've got them broken up by item numbers. Item 1, this citation was for grounding cables. We can kind of go through all the language, but at the end of the day, this shop has a 55-gallon drum of virgin lacquer thinner, and they did not have it adequately grounded. Because of that, they were assessed a penalty of $2,400, and they have to have it abated by June 26th. So you're going to notice that word abated a lot. That means corrected. So the distinction here is if you correct it, if you abate it by June 26th, that doesn't mean you do not have to pay the penalty. The penalty for $2,400 is in addition to the fact that you must correct this by June 26th. And if it isn't, then you're subjected to potentially bigger penalties and more penalties. So don't think, hey, if I get this done, I don't have to pay the $2,400. That's not what this documentation is saying. It's an and, not an if. So no grounding cables on the virgin thinner was $2,400. Item 2 was the job hazard assessment. This is a paperwork item. Notice the intimidating and somewhat confusing language. 29 CFR 1910.132 D2, employer did not verify workplace hazard assessment had been performed through written certification that identifies workplace evaluated, the person certifying the evaluation had been performed, the dates of the assessment, et cetera, et cetera. This is very much drafted by attorneys and by regulators. And typically most shop owners have a hard time with understanding what this language means. And in this instance, this is just a hazard assessment needs to be done. If you remember in my section earlier on paperwork, a hazard assessment is how can my guys get hurt? If I'm a body tech, if I'm a painter, how can I be injured? What do I need to make sure that they're wearing from a personal protective equipment standpoint? This shop didn't have that document on file. They've been assessed a $1,600 penalty, and then they must develop one and implement it by June 26th. That's the date that it has to be abated. Item number 3A, this was a safety glass issue. Essentially, what they're citing them for is that a painter or someone that was exposed to isocyanate vapors did not have eye protection. Now, the thing that I want to point out with this, it's very important, is this was not observed in the shop, okay? This inspector didn't see the painter working in an area that required eye safety and then cited them for not having it. This was relied upon based on an interview with the employee where they asked, when you're spraying, what kind of PPE are you wearing? The employee did not answer safety glasses, said they were not wearing them, and so they were assessed a penalty of $1,200. And then they must correct that by June 26th. The reason why that's important is just because someone doesn't witness something doesn't mean OSHA doesn't have grounds to issue citations or penalties. And the reason why I say that is most shops have issues with paperwork. So if I'm an employee of a shop and I'm disgruntled, or maybe I just gave the wrong answer because I was nervous, and I said, no, I don't have safety glasses. Well, if the shop has nothing to fall back on from a paperwork standpoint, they're going to issue a citation there. This particular shop had no documentation that said anything contrary to what the employee said. Whereas if an OSHA inspector talks to a technician and they say, no, I don't normally wear safety glasses in the booth, but you have a hazard communication program that says this is the requirement and policy and procedure manual. If you have a hazard assessment that says eye protection must be worn, if you have training that says eye protection must be worn, and then you have a sign-off sheet that employee received upon orientation and their first day of work that they know that they have to wear eye protection, and then you've provided that to them, you have a better leg to stand on that employee is acting out of the culture of the organization as opposed to it being an organizational issue. Because they don't have paperwork, the inspector saw it as an organizational issue and issued them a fine of $1,200. Page 4, or item 3B, page 4, is an eye wash station issue. A technician needed to move some equipment and unplug the eye wash. So it did not have any type of water or any type of fluid flow to it. They fixed this issue when the inspector was still there, and you'll notice it says quick fix applied. It's still being documented as a citation, but they didn't issue a penalty for that. Now, not every quick fix means you don't pay a penalty, and I'll show you an example on that when we get further through this packet of material. Item 4A, page 5, this is another paperwork item. The employer failed to have a written respiratory protection program in place. What that means is that, again, they don't have a business plan dealing with the cartridge-based respirators in their business. So what respirators are we wearing? What respirators are required when we're painting versus when we're buffing versus when we're sanding versus when we're grinding? How often are we going to change them? What's the medical evaluation process? That sort of thing. Because they don't have that plan, similar to the hazard communication plan, they're also fined $1,600, and it was need to be abated by June 26th. Moving on, page 6. This is item 4B. This is a part of the respiratory protection program. Essentially, the employees that are wearing respirators didn't have a medical evaluation. Kudos to the jobber distributor for this particular customer. They were notified that the OSHA inspector was there asking for medical evaluations, and were able to coordinate and get the medical evaluation done the same day that the inspector was there, so they didn't receive a penalty. So they were able to jump in there and take care of that and save this customer from a penalty. But, you know, realistically, medical evaluations need to be done for almost everyone in the shop nowadays, because almost everyone's wearing some type of mask, whether it's a paper dust mask or a cartridge-based respirator. So your body techs, painters, helpers, buffers, all typically are going to have to go through this medical screening. And then the second part of this is the fit testing. So this one, you can't do a fit test until you've had medical screening and medical approval. So if you have a company comes in that does your fit testing, for instance, they will not fit test individuals that haven't gotten medical clearance because they're not going to take on that liability. So this wasn't corrected that day because they were still going through the medical evaluation process, but they were able to resolve it within a few days, and they were not assessed a penalty for it. Page 8, this is still citation 1, item 4D. This is someone that was not clean shaven. Typically, it's something that we all know. We all know in the industry that our technicians are supposed to be clean shaven, but we're just very lax about enforcing it. And OSHA has started to issue citations for this because they know that businesses are being lax in this area. Luckily, this particular shop didn't get a penalty associated with it, even though there was a citation. However, I want to take a moment to talk about this very briefly. Typically, when a shop owner goes through an OSHA inspection, if there isn't a penalty, if there isn't a dollar amount associated with it, it gets thrown to the bottom of the list. And it's one of those, well, yeah, I was doing something wrong. Yeah, I was out of compliance, but it didn't cost me any money, so I'm not going to make it a focus point. I'm not going to make sure that we address this. And you have to be careful with that, because as a part of this experience, as a part of this inspection, this shop owner is going to have to sign paperwork accepting all of the violations, not contesting them, accepting them as if it happened. What that means is, even though this inspection didn't have a penalty associated with it, didn't have a dollar amount, if OSHA comes back in 2 years or a year and they find another employee that's supposed to be wearing a tight-fitting respirator and is not clean-shaven, when they issue the citation at that point, now you get into a repeat and willful classification. Essentially, you're a repeat offender of this particular standard. Now the penalties go from $1,000, $3,000, $4,000 to potentially $25,000, $30,000, and $35,000 because you've been warned before from OSHA you have to get this done. Now they're going to be even more strict because you failed to follow that. So just because there's no penalty, no dollar amount, don't ignore it. Page 9, item 5A is another paperwork item. This is the hazard communication program. You'll notice in the language, use of labels, access to data sheets, hazardous chemical information, that sort of thing. This is a conjunction with the respiratory protection program. No paperwork, no business plan for this, $1,600 in penalties, and they have to have it devised and implemented by June 26th. Item 5B is the extension of that, which is the training. If you have a hazard communication program in place, you have to provide training to your technicians. This didn't have a dollar amount because they already levied the dollar amount from the item 5A citation, but they still have to complete the training by June 26th. And then my last one, other than serious, this is that example of a citation that was corrected on the same day that the inspector was there, but they still went ahead and assessed a penalty of $1,000. This is another paperwork item. OSHA 300A is that summary of injuries and illnesses. So this inspector was there April 14th. It's their requirement to have this posted in the break room through April 30th. It is literally a one-page document signed by the business owner. Because they did not have that, even though they fixed it while the inspector was still there, it cost them $1,000. So all told, we were almost $10,000 in penalties for this inspection. 6,000 of the 10,000 were tied to paperwork. So it reinforces my point. When you ask, what is my shop doing right now that makes me not compliant, it's probably going to be paperwork. Moving on to mailbag question number 3. Let's say I get an inspection and I get this notice of violation and citation. How do I negotiate a fine from OSHA once I've received one? And the quick answer to that is you have to respond very, very quickly. Again, once you receive that paperwork in the mail, the clock is already ticking. And you have a 15-day window. I'm going to show you what this abatement certification looks like, and it should be refreshed on your screen. Essentially, you have 15 working days from the date of receipt to complete this form, essentially documenting the citations, the item numbers, and then what you did to fix the issue. So if you had an issue with grounding straps being applied to virgin thinner containers, what did you do? How did you fix it? If you needed to make sure your employee was clean shaven, how did you fix that? So this particular shop is going to have to make several copies of this worksheet because they had more than 6 citations. They're going to have to do this for all 11 of them, and it has to be turned in within that 15-day working period. The thing that can get a little bit tricky is this is the first couple pages of the paperwork that comes from OSHA, citation and notification penalty. You're getting a 20-page document, and it's telling you that you owe $10,000, and it's using language that you're not really comfortable with. Typically, we skip over the introductory paragraphs and go right to the dollar amounts. But if you notice at the bottom of this first page, it says informal conference. An informal conference is not required. However, if you wish to have one, you can meet with the area director during the 15-day working contest period. If I go to the next page, it's going to talk about the right to contest. It's going to talk about what happens with an informal conference. What this boils down to is if you want to negotiate these penalties, upon receipt of this paperwork, you need to not only notify them, you have to have this meeting completed within that 15-day period. You can't wait until the end of your 15-day working day period and then request the meeting, because now your right to contest has ended and the citation, notification, and penalty has become essentially firm, and you now owe that $10,000 in this particular example. So if you want to negotiate these penalties, these dollar amounts, if you want to contest them, you need to, upon receipt of the paperwork, act very quickly, read through the documentation, understand what they found, and request the conference with the area director of OSHA immediately. You can do it by phone, you can do it by certified mail. Usually a quick phone call and letting them know is adequate. But then once you've scheduled it, and they'll schedule a date and a time, you have to post that notice in the break room to allow your employees to know that you're contesting the OSHA inspection and you're going to be meeting with the area director on a certain day and time. Then you'll want to bring all of your documentation, pictures, invoices, receipts for maintenance that you did or equipment that you bought. If you had to implement a new plan, bring the plan with you. Essentially, you need to show up to meet with the area director to be able to answer his or her questions. Okay, citation 1, this was your issue. How did you resolve it? And how do we make sure it doesn't happen moving forward? The key thing to understand is this is a negotiation. OSHA doesn't necessarily want to go to court. They don't necessarily want to drag this out. So they're willing to be flexible with you on the penalties if it seems like you responded the way they wanted you to respond, you addressed the issues, and you've made corrective plans to make sure they don't happen again down the road. If you do those things, they may be more lenient. They may take a 20, 30, 40% reduction in the penalty. If there's severe issues, if they are a response to a complaint by an employee, they're going to be less likely to bend. It just depends on how your negotiation goes. If you still do not like the terms of the settlement with that informal conference with the regional director, you still have rights. You can file a right to contest, and essentially you are now going to court with OSHA. So typically a shop's going to have to hire an attorney. It's going to drag out. And then they have to put together documentation as if you would any other court case. So just because you get an invoice in the mail from OSHA doesn't mean you have to pay that amount. But if you do not jump on this quickly, if you wait 2 weeks to respond, you've now essentially forfeited your rights to be able to contest and be able to negotiate this and be able to provide documentation because you just didn't act very quickly. Moving on to number 4. So I know what I'm doing wrong. I know what I have to do when I get an inspection and when I have the paperwork coming to me. I know how to negotiate. What are my chances that I even have to deal with this? What is the probability of a shop receiving an OSHA inspection? And I wish I could give you a number here, but I really just cannot. It depends on too many factors. It depends on what state you're in. It depends on if there's an emphasis program. The state of Colorado, specifically in the Denver area, has an emphasis program currently on lifts. So OSHA is going out to more automotive businesses because of lifts. That's on top of a federal emphasis program in isocyanates where we're seeing increased enforcement activity. So I really can't give you a number here, but what I can is show you kind of the macro level trends, which is, we had an increase in budget for enforcement back in 2009. And when we look at OSHA inspections in our industry over the course of a couple years before the increase in funding, we were right around 2,000. And since then, we're now up 50% to where we're right around 3,000 inspections. So we have seen a significant increase in enforcement in our industry specifically. This is tied between two things. One, because of the increased budget, but also because of the national emphasis program in isocyanates, where OSHA is trying to coordinate their enforcement activities specifically for these businesses. Not just collision repair, but businesses that have isocyanates in them. The other thing that I caution shop owners on to keep in mind is you're only a phone call away from an OSHA inspection. If an employee is disgruntled, if there is a major injury, if there is some type of a major hazard, that sort of thing. OSHA has to respond to these things. So an individual that was to contact OSHA and say, hey, this is an unsafe workplace, that could lead and that could trigger an OSHA inspection right there because they're going to have to respond to that citizen, the person that they're there to protect, which is the American worker. So how likely? I have no idea. That's the short answer. But from a macro level, we're seeing increased activity, and there's always the risk of getting a complaint. So, changing gears a bit, one of the things that I was asked to spend a little bit more time on is what exactly GMG EnviroSafe does for the shop to keep it in compliance, essentially. Most shops aren't spending a lot of time thinking about risk management. They're not thinking about regulatory compliance. They want to do the right thing. But you just have a lot of things on your plate. So what we do is essentially our service is called the Compliance Department, and the idea is we want to try to take some of that off of your plate. We're going to provide expertise, we're going to provide resources, we're going to provide visibility, provide you some talent and some tools so that as these things come up, we can be proactive about them, and if there's a major concern, we can handle it for you without it being overwhelming. So we're the largest environmental health and safety company dedicated to body shops around the country. We have team members that are experts in some pretty challenging content areas like how to get permitted, licenses. We have people that deal with interpreting regulations. We have people that talk specifically to inspectors and enforcement to make sure that they're following the letter of the regulation, because it is possible that an inspector interprets a regulation incorrectly. And then we have individuals that handle chemical inventory, SDS sheets, that sort of thing. We also have been the industry leader on regulations and getting that content out to the industry at large. So 5-6 years ago when EPA 6H NESHAP was going on, we were dealing directly with the regional coordinators for EPA, trying to understand how this regulation was going to be implemented. And then you've heard from me now on the hazard communication changes from 2012 and the isocyanate emphasis program and spray suits that we've dived in on. On the major liability side, most shops don't have a game plan for what happens if they get an OSHA inspection, or, and this can be even more painful, if a regulatory agency starts to launch an investigation or issue a subpoena or starts to gather some documentation because they feel the business is doing something they shouldn't be doing. We have experience navigating those issues. We've dealt with hundreds of OSHA inspections, dozens and dozens of settlement conferences. We worked in these areas to really be able to provide a shop the ability to have someone that's not charging them very expensive lawyer fees that is going to essentially make it useless to contest these things. I mean, if this shop that I showed you has a bill for $10,000, they're not going to spend $10,000 on attorneys to fight that. You know, there's some economies there that they have to balance. So we've got experience navigating those kind of major liability areas. In terms of how we go about it, our compliance department solution, we do ongoing safety training by people in the field all over the country. We do quarterly safety and environmental inspections. We do training with your personnel, with your staff. We do that in person. We go over personal protective equipment, that sort of thing. Monthly safety meetings. We handle all of the paperwork, so those written plans, inspection logs, that sort of thing. We handle all those things. We also developed a customer portal where you'd have real-time access to your assessments, your scorecards, your permitting requirements, all your documentation, and your employee data. Forgive the poor screenshot of the way my laptop is formatted, but at least you can kind of see. You'll get essentially access to our portal, which basically has a trend line and gives you a score based on what we think you're performing as it relates to OSHA and EPA and environmental. Focus areas that detail the areas of the business that are most at risk for injury or for citation, and then a speedometer or tracker for how much of your employee paperwork is current. Those would be things like medical evaluations, fit testing, that sort of thing. And then we also have online bilingual and Spanish and English training for technicians, to where you'd be able to have your personnel sit down when they get hired, go onto the website, and within 25-30 minutes go through the required training, take a test and pass it, and then move on. Then the owner or the manager has validation that they've completed all the requirements for new employee training, that sort of thing, as it relates to OSHA and EPA. Beyond that, we handle all safety data sheets. We have a database of more than 30,000 chemicals specific to the collision repair industry. If it's something that's sold to a body shop, typically we already have a data sheet for it. So we do all the heavy lifting to make sure that your documentation is current. We put it all online and customize it specific to each business. And then we're also available when things get a bit out of hand. So we have on-call services for consultations on safety issues, environmental inspections. If you had an OSHA inspection or you needed to turn in a report for VOCs or emissions or hazardous waste, you know, whatever that is, we have those services. And we also work with third-party laboratories to do testing of dust and boot filters and waste and air quality, that sort of thing, to be able to give you a clear answer on what your responsibilities are as a producer of that hazardous waste. Now the million-dollar question, what does it cost to add GMG EnviroSafe compliance department to my shop? As you can imagine, this is a complex service offering. There's a lot of different moving pieces here because we're doing safety and environmental, but the easiest way that I can break this down for you is it's between $49 and $299 per month. The service is called the compliance department. The idea is the shops need to tell us how active, how much do you want us to be involved, how big of a department do you want, and that corresponds with the dollar amount of the service fee. I have a price list here that breaks it out even further. Essentially, you have 4 buckets ranging from that $49 to $299. There's a lot of information on here. There's a lot of content. I'm not expecting you to be able to digest all this information, but I wanted to show you that we have service offerings that are great for the smaller operation, 2 or 3, 4 people in the entire facility that need paperwork, but they can manage it themselves. That's a DIY approach where we handle everything. From a paperwork standpoint, training, you get our expertise, but then you implement all the way up to where we do everything for you, and you kind of have everything in between there. So I'm not going to leave this up there for too long. If you wanted additional information on our services, our pricing, if you wanted that particular price list, you are more than welcome to contact me. My name is Brandon Thomas. There's my email address and my phone number. I believe Melissa will also be communicating this presentation out to all attendees, so you'll get a copy of that as well. And at this point, I'd open it up for questions.
Yeah, I just want to follow up by saying everybody who's on this webinar will get Brandon's contact information directly emailed to them. And I can also give you a PDF of the presentation, but we'll have it recorded as well, so it'll be available in a couple different formats. I don't see any questions. Does anybody have any questions for Brandon?
I either put them all to sleep or I answered all the questions in advance.
Very informative, very informative. Well, if we don't have any, you can follow up directly with Brandon. I don't think we're getting any. So that concludes the webinar. Thank you, Brandon. Again, it was really, really informative, and continue to send us your suggestions, everyone, and we'll be in touch with future webinars. Thank you.
Thanks, everyone.